welcome to Legally Speaking with me, Tarun Nangia. Prime Minister Narendra Modi, not too long ago, made a statement that he wishes to see India as the hub of arbitration, a nation of 146 crore people, the fifth largest economy. We have to do something that makes India a place where people do arbitrations. And a step in that path is the draft Arbitration and Conciliation Amendment Bill 2024. Will it take us to our sort of stated goal that India should on its way to be becoming the hub of arbitration? How will that be done? Are there any improvements that are necessary? We have a panel of experts that will give their inputs for India to achieve that stated goal and to be the preferred destination for companies who also do business in India to only arbitrate here. What all needs to be done, and what suggestions of what more needs to be done. All of that and more on the show today. I would like to welcome Senior Advocate Sanjay Jain. As we all know, he's served as the Additional Solicitor General of India for 10 long years. Now he's back to private practice, does arbitrations, and is at the Supreme Court. Good to see you, and looking forward to some interesting insights. We have with us Senior Advocate Percival Billimoria, counsel at the Supreme Court of India, also does international arbitrations. Good to see you, Mr. Billimoria. We have with us.
Nice to meet you.
We have with us Tahira Karanjawala, partner with Karanjawala and Company. She is part of the dispute resolution practice and also at the Supreme Court. Good to see you, Tahira. We have a new guest today on the show, and we would like to welcome him because he joins Legally Speaking for the first time. We've spoken offline, but it's the first time that I get an opportunity to welcome him. Vyapak Desai, partner with Nishit Desai and Associates, a vocal person. He has, in a sense, a mind of his own on issues and is not afraid to speak what needs to be spoken. Good to see you, Mr. Desai. And
thank you. Thanks, Tarun.
Looking forward to your insights on the issue. At the outset, let me request Mr. Jain to open, and then we'll go to Mr. Billimoria. Over to you, Mr. Jain, for the opening comment.
See, as a opening comment, I would like to mention that if one was to go for amendments, it was expected that the amendments would cover a wider spectrum. For instance, one finds that there is no proposed amendment in Part 2. Whereas if we are looking to make India an arbitration hub, a great deal of work needs to be done in relation to the enforcement of foreign awards. So on that aspect, if we see, it was a golden opportunity to do away with the reciprocity requirement in Section 44. And if we dwell further, Section 48 contains about 7 grounds on which the enforcement can be declined. In spite of that watertight situation, and in spite of Supreme Court holding that now it is a one process in the sense that unitary process, it doesn't require two-stage enforcement. In spite of that, we are seeing that many a foreign award are having a sluggish journey in this country in various courts. So there was a need to streamline the regime of Section 48 and the allied provisions which are part of Part 2. So that is one area where I feel it is a case of a missed opportunity, but of course, we are still at a stage where this aspect can be covered up and we can make good this deficiency. The other aspect is that what we wish to introduce is showing an inclination that we want to reduce the limitation period for approaching courts in different situations, which in my view is not correct, because if you see, Arbitration Act says that you give equal opportunities to the parties. And if you have to give equal opportunities, that means that you have to give equal opportunities even after the award is passed. So merely because somebody is a judgment debtor, so you squeeze his time to approach the court is not correct, because the stakes are high. Judgment debtor also would like to choose a lawyer, to have a lawyer. He would like to be represented by a lawyer of his choice. It may take some time, the lawyer's availability. It may take some time to prepare the matter. So therefore, squeezing these limitation periods to 60 days, etc., is not correct. For instance, it proposes 60 days for Section 37. It is not correct. I mean, give at least minimum 120 days, which is available for 34. That's my opening comment.
Thank you for the opening comment. We'll come back to you for more. I'll go to Senior Advocate Percival Billimoria for his opening line.
So, Tarun, a tale of missed opportunities is what I say if the bill in its current form becomes law. First and foremost, I'm a great believer in saying that, look, our act has, by and large, based on the UN Citral Code, is very, very well casted. The problem is always been in the way arbitrations are conducted, the process and the proceedings, not so much in the law. Now, one of the major bottlenecks to speedy disposal has always been not that everyone prefers a challenge. I mean, it's your right to prefer a challenge if you believe that the award deserves to be struck down. But the fact that the court in which the challenge is preferred, so there are some jurisdictions, so for example, Chennai, where the pecuniary jurisdiction is such that it has to go to the court that has the original civil jurisdiction, which is the district court. And in some of these situations, it languishes there for years together. See, the point is that the district court judges are not really well versed with arbitration and the concepts of arbitration. So this is one difference. The law already says that if it's an international commercial arbitration, so very briefly, it means that one or the other of the parties is not domiciled in India. That's a sum and substance of the legal definition. In case of an international commercial arbitration, the challenge will go to a high court, regardless of any other criteria. But here, for other domestic arbitration, we still have to go to the civil jurisdiction, except, for example, in Delhi, it's different because the pecuniary jurisdiction is only 2 crore, right? So that's one thing that we could redress. The other thing to take up from what, Mr. Jain said, you cannot compress times, and statutory time limits is not the way. I mean, if one is concerned about the time that arbitration takes, there are other ways to do it. So you cannot say that, for example, a Section 8 application should be decided in 60 days. It never happens. See, even now, for a Section 34 challenge, there is a time limit for a year. But please tell me whether this time limit is followed more in breach rather than, as a rule. That is indeed the case, because even if it is, see, all these people who say that, okay, it's a shall, so it is mandatory and all that. Let's be very practical. Stop being academic here. Okay, are the courts today geared to finish these applications within the prescribed statutory time limit? The answer is absolutely no. And the third difficulty, which I have very serious reservations, is this arbitration council. Right, we are introducing one more body, and this is manned by bureaucrats. These guys are going to decide fees. It's going to recognize institution instead of grading. Thankfully, they are going to make rules for emergency arbitration and rules for an appellate tribunal. Yeah, I mean, I shudder to think, the road that we are traversing.
Thank you for the free and frank comment. Maybe some changes will happen soon. I'll go to Tahira Karanjawala, partner with Karanjawala and Company, for her opening comment.
Thank you, Tarun. As Mr. Jain and Mr. Billimoria said that, there are some amendments which have been brought about, which are, which are relatively insignificant, and some which are more significant. As far as my view on this is concerned, see, there are 3-4 broad areas which this arbitration bill seeks to address. One is, of course, as both seniors were mentioning, the timelines. So in my view, some of the timelines that have been set may be useful, but certain timelines, for example, the Section 8 timeline, 60 days to, for a court to adjudicate a Section 8 application, is unrealistic. Section 37, again, 60 days to prefer a challenge is again unrealistic, especially if you're going to make it mandatory and after that there's going to be a guillotine beyond which you can't make the application. But I do think 2 or 3 of the timelines that have been introduced are good. One is, of course, the section 9. They have clarified that within 90 days of filing the Section 9 petition, one should initiate the arbitration process. So I think that is a good suggestion, because what was happening is that parties were moving a Section 9 petition, and then they would just take an interim order and sit on that order and not actually initiate arbitration. So I think making it mandatory to initiate arbitration within 90 days of filing that application is better than the current prevailing situation, which was that you have 90 days within 90 days from getting the order in the Section 9. So I think that's one good change that has been suggested. The second good change that has been suggested, I think, is something that actually flowed from Justice Indu Malhotra's judgment in the BSNL matter, where it was highlighted that there was actually no time frame for moving a Section 11 petition once there is a refusal to appoint an arbitrator. The court recognized that Article 137 of the Limitation Act applies, and you have 3 years within which you can move that application. Now, this it had created a situation where people would simply to stop the limitation from running would send a notice invoking arbitration, but then may not follow up and actually move the court for appointment of arbitrator if the other party did not appoint such arbitrator. So now they have made it mandatory within 60 days. I think that's a good suggestion again. So I think these two timelines which have been brought in have been good suggestions. There is one change in Section 34 that I think is a commendable change, which is that they have recognized that there may be grounds which invalidate the entire award. For example, procedural grounds like the incapacity of a party, or if the arbitration agreement is not valid under the law, or if the composition of the tribunal has not been, it's not in accordance with the agreement of the parties. And this sort of goes to the root of the award, and the entire award should be set aside for this reason. But there may be other grounds which do not touch upon the entire award, but go to only a few issues in the award. For example, a patent illegality. Not every claim may be visited with this, with this shortcoming. Or if a particular, a particular part of the award is contrary to public policy, or beyond the scope of the, the submission to arbitration. So in this situation, the legislature has now recognized that an award can be partially set aside. This was, of course, being judicially recognized in the last couple of years, in any case, by the courts. But now this has been sort of spelled out by the legislature. But there are two changes in Section 34 which are of concern. One is the, sort of the option which a party has now been given to go to the appellate arbitral tribunal under, constituted by an arbitral institution. Now, firstly, an arbitral institution, that, it's also, it's a wide term. It's in fact been widened further, where they say that it doesn't have to be designated by the Supreme Court or a High Court. It can be in any institution. Now, it's very unclear at what stage the parties have to agree to this. Is it something that has to be done when you are entering into the arbitration agreement? Is it something that can, that it's an agreement that has to be reached after the award is passed? The provision also says that if I move the appellate tribunal, then I cannot move the court. Now, it may be that, both the respondent and the petitioner may both want to challenge the award. What if one goes to the court? Are you then precluded from going to the arbitral tribunal, appellate tribunal? So certain aspects of this are not clear to me. Also, in general, I'm a little conservative. I mean, I don't think so much jurisdiction should be taken outside the the purview of the high courts. I think there's good reason for why there are fully qualified judges adjudicating these matters. So therefore, I feel that I'm concerned. I mean, at a theoretical level, it's one says that you should minimize judicial interference, but sometimes, as we all know, practically you see sometimes how awards are being passed. So to further add one layer into the private sphere is of concern to me. And the second change in 34 is that patent illegality, which was never a ground for an international commercial arbitration, is now being, sought to be included for international commercial arbitrations as well. And I think that would be of concern to the international community as well, because it's not, in tandem with the international framework. So these are the slight concerns as far as I'm concerned.
Thank you for detailing out points and concerns both. We'll go to Vyapak Desai, partner Nishit Desai and Associates, to his opening comment.
Sure. So I'll keep it brief for the opening comments, Tarun, and thanks a lot for inviting me. As you said, it's my first time, and I'm very, very happy and feel good to be part of this group. So thanks a lot again for that. So coming to the topic today, right? I think we are talking about amendments to the arbitration, and it seems that we have been talking on this subject for almost 10 years now. And I think this is one major point I wanted to highlight. Arbitration is all about resolving disputes for businesses. And one thing businesses hate is uncertainty or unpredictability of how their disputes will be resolved, right? So, yes, we need certain amendments. Yes, we need some changes to be done with our law. But I think at some point in time, we need to get to the final version of this, because since 1996, for almost 20 years, we kept on doing whatever we did with the 1996 Act till 2015. And then came the most awaited amendments in 2015, which took a while, 3-4 years, to even decide when it will be applicable and in what kind of cases it would be applicable, retrospective, prospective. Then came 2019, then came committees after committees, and now we have a bill. So I think my first point is, let's make sure that we use this opportunity to the fullest. And for another decade or so, we don't see a discussion on amendments on legally speaking going forward. That's first thought on this. But coming to more merit issues, right? I think 3 points I want to raise as a part of the opening comments. First, I think we, right from Venture Global to Bhatia International in the early 2000s, then 2015, in between patent illegality applicable to domestic versus international and foreign arbitration and so on and so forth. I think the time has come that we need to split our laws for domestic arbitration and international arbitrations. I think we are making a hash of it, whether it is Section 9, emergency arbitration, and I'll come to each of those if we have some time to discuss in detail. But each provision, including Section 34 grounds, which I think Tahira talked a little bit, timeline in courts, which I think Mr. Jain and Percy talked about, everything is getting muddled between domestic arbitration versus international arbitrations. So I think if we are going for an overhaul, my first ask would be to split this into 2 different acts so that there is no confusion what applies to what kind of arbitrations. And I will make this point more detailed or more clearer when we talked about interim reliefs, challenges, emergency arbitration, seat, and many more. Everything has this constant issue about what will apply to what. So that's my first point. Second point is, my friends talked about timelines in courts, but I think a lot has been said earlier on timelines for arbitration itself, because we were the first country in the world to bring a statutory limit to arbitration. I have never heard this elsewhere in the world, but frankly, it has worked well for us. I think we as Indian community needs timelines to finish our jobs, so that's fine. But my thought is that complicating it with not applicable to international commercial arbitration, applicable after pleadings are filed, again going into litigations, I don't think we are meant for that. My suggestion is split or cut the cake into simple 2 things: ad hoc arbitrations and institutional arbitrations. and that will give a big boost to what Justice Sri Krishna committee was formed, and what even the current regime is talking about, institutionalizing of arbitrations. So cut the cake into two. Ad hoc arbitrations, keep a simple time limit. You want 2 years, take 2 years. You want 3 years, take 3 years. But make it very simple: date of invocation, date of the award. Don't get into the territory of arbitrator when pleadings are complete, when the time has to be calculated, and so on and so forth. For institutional arbitration, leave it to the institutions, because that's where complicated arbitrations, multi-party arbitrations, maybe issues which require less or more time, institutions and arbitrators will deal with it. And even for extensions, for institutional arbitrations, extensions can go to institutions. For ad hoc, of course, courts are there, so that will also reduce a big burden on 29A and so on and so forth. So that's my second thought on a larger point. And the third is, look, any dispute is as good as execution, right? We fall short of looking at these amendments only up to recognition of an award or challenge of an award or enforcement in a foreign situation. What about execution? So unless you also consolidate execution as part of this, maybe some other laws have to be amended. And there again, I have a very different view in terms of what can be done by courts and what cannot be done. And taking a cue what IBC did, everyone thought, how can you appoint private practitioners to become IRPs? How can COC take a decision? You are taking away official liquidator government job and giving to private persons. But largely, maybe people can debate, IBC has not worked out and all of that, but at least it has not gone that bad as people predicted when there was a sea change in the way we dealt with our restructuring and liquidation. I think it is important that now we look at execution in the same way. We can have private execution practitioners appointed to do many things, and only take court support, like people go to NCLT for support in IBC. But unless we make our execution better, anything and everything we are doing with the process of dispute resolution is not serving the purpose of the business for which we are here talking about the process of arbitration. So I think these are my three major points, and then of course I have some detailed issues on interim relief and emergency arbitration and challenges and the appellate tribunal, but I'll come to that as the discussions go along. Thanks a lot.
Thank you so much for your opening comment. We'll go to Senior Advocate Sanjay Jain. Two specific points. One is, now we have statutory recognition for emergency arbitration. That is a sort of thing which has now been formalized. It happened, of course, we saw in the Amazon case, but now for domestic arbitrations is applicable. Secondly, there is a question, Mr. Jain, you've been part of the government, so I think you're the right person to sort of opine on this. The guidelines issued by the Finance Ministry on June 3 last year, where they are limiting arbitration to disputes of less than 10 crore. This virtually means that there will be no arbitration between PSUs, involving. What is the implication? Do you think the government needs to roll this back ASAP if we have to make headway and India has to become a sort of hub of arbitration, or, there is so many people now working in this practice area? Over to you for comments on these both issues.
See, so far as those guidelines are concerned, though of course the subject is unrelated to the amendment per se, but as I understand from government's point of view and particularly PSU's point of view, the situation that was emerging, that given a very limited scope in Section 34, and especially if one of the parties is a foreign party, then patent illegality having been taken away, then practically you hardly have a case in 34, even if the award is bad. So therefore, there was not much of a logic in keeping patent illegality for domestic parties. Now that the tenders are floated at global level, So it is very easy for a domestic player to just have a consortium with a foreign party and kick him out after some time, just make it just a sleeping partner, and then take advantage of patent illegality ground being knocked out. So, so that is one aspect. Secondly, the manner in which some of the awards were being rendered, which also compelled the government to bring the issue of fraud, etc. So the PSUs were feeling a great deal of heat because of the monumental awards which were being passed, or the awards which were being passed without any evidence, the fanciful amounts being asked in the claims and being granted. So therefore, perhaps it was a sort of a forewarning on the part of the government that please see, if you either you rectify the system, all the stakeholders, the private players, the arbitrators, either all of them should have some kind of a minimum self-discipline and a code to follow. The system is not abused or misused. So therefore, the forewarning call of the government is reduced into writing in the shape of this directive or a guideline that the PSUs are advised not to go for arbitration except in X cases or Y cases. I don't think that it is intended to be followed in the long run, and I am quite hopeful that it will be recalled or it will be relaxed. But the hidden message must be understood by all the stakeholders, is what my comment would be. Now, coming to the amendment part, my colleagues on the panel have raised some very interesting issues. Now, as has been pointed out by one of us, that it is time that if we are going for the amendments, these amendments should bring some amount of finality to all the pending issues. And it should not be a situation that after 1 or 2 years, we should be looking for another amendment. So for instance, if we are clarifying certain issues which had been a part of huge conundrum and a lot of litigation, for instance, seat and venue. Now, in section 20, what is proposed is that the place of arbitration be substituted by either the seat or the venue. Now, if you substitute it by only one of the two expressions, the other expression will still beg for an answer. So why don't we make it more clear that instead, why are we so obsessed with the expression place of arbitration? We should categorically clarify that, say, for instance, where the contract has been entered into would be the seat of arbitration. And the venue is completely unrelated to it. So wherever the parties decide to hold the arbitration mutually with mutual convenience would be venue. So these aspects can be clarified in a greater clarity, but the proposed section 20 doesn't seem to be achieving that particular objective. Similarly, if you see 16.5, the objection to the jurisdiction of the arbitrator. Now we all know that if section 16 is allowed, 37 is permissible. If it is disallowed, then you have to wait till 34. Then why to bring this, I would say, ineffective amendment and making it more difficult, as it is, the timelines are very difficult to be attained, that 16.5 objection should be decided in 30 days, or the arbitrator may give reasons for not doing so and take it up at the end. Now, 99.9% cases, the second option will be availed by the tribunal. They are never going to decide 16.5. Then either you don't keep it in the statute book, or if you keep it, make it meaningful. This system is inculcated or introduced to make it meaningful, not for a cosmetic presence. So you are making 16.5 absolutely cosmetic. If somebody has a genuine case of 16.5, it should be made mandatory for the arbitrator to decide one way or other. He may be given, the tribunal may be given a huge amount of powers to put huge amount of cost on frivolous applications. But to give them an option not to decide it, if they are not unable to decide it in 30 days, in my view, is not achieving the purpose. And this amendment is going to bring more difficulties and more discontentment in the whole mechanism. Similarly, 34A, Tahira has mentioned that there is we hardly have institutions of credibility. So now if we are going for a 34A, and as it appears from the structure of the amendments, even a 34A decision will be subject to 37. So ultimately, what are we achieving? If ultimately we have to go to the destination of 37, and we are only creating an alternative mechanism to 34 on the presumption that maybe the courts are clogged with 34 petitions, so therefore you give it to the to these kind of appellate tribunals. So, but for these appellate tribunals also, there has to be a strong regime which the Act doesn't address as to how that regime of appellate tribunal it proposes to achieve. So these are some of the areas where I feel that the amendments, when we are going for amendments, the amendments could have been addressing them with the greater alacrity and not with a myopic approach, and keeping in mind the balance for both the parties, reducing these time limits for the adjudicatory bodies to decide it in the lesser time, or reducing the time limit to approach a particular forum is not the solution. The solution is to revitalize the whole system, to infuse a different kind of ethos in the system, and for which perhaps what can be done is the suggestion which has been given here, that maybe for foreign awards and for domestic arbitrations, we can have two different regimes, because I am hugely worried that the proposed amendment doesn't propose to do anything about part 2. So that is my concern.
Thank you, Mr. Jain, for the your frank suggestions and also observations on this issue. I'll go to Senior Advocate Percival Billimoria for his intervention on the same 2 points.
So let's take up the point of 16.5, which is the issue of jurisdiction of the tribunal. Now, for long, it's been recognized that a tribunal can decide on its own jurisdiction. Now, what has been happening in India is some of the jurisdiction pleas that have come about include, for example, res judicata. Now, to my mind, res judicata is something that must be settled up front. Res judicata means that the subject matter has already been decided between the parties. And in fact, it is something that it should be taken up at the stage of Section 11 itself, when the courts appoint the arbitrators, we are seeing that trend. So despite subsection 6A, which has now thankfully been removed, 6A said that you will only look at the question of whether there is a arbitration clause and then appoint an arbitrator. But I think the courts have been looking at res judicata. They've also been looking at limitation. So where there is a dispute which is ex facie out of limitation, there's no point in appointing an arbitrator and going into arbitration. And then the same objections come in Section 16 before the tribunal. And because of the way the case law panned out, the tribunal was able to say, I will deal with this in the final award. Now, just imagine a situation where there's a final award which says that, oh yeah, we didn't have jurisdiction. So why are you dragging the parties through this whole rigmarole of a long drawn out process of arbitration when there is no jurisdiction at all? And I think ultimately here, the law has been well settled. So there is one decision of the Delhi High Court, I think Justice Pratibha Singh, she has said that it should be decided at the earliest possible time. Now, earlier, what happens is that if there are mixed issues of fact and law, then you cannot decide it initially. There has to be some evidential proceedings. But the earliest point of time means at least after evidence, without waiting for final arguments, you can decide the 16 straight away. And that today is the extant law. Of course, the tribunals do not follow that. That's another issue. But I think there's very little to be said for a provision that says that, well, you will decide it upfront as a preliminary issue, because sometimes the jurisdictional challenge need not necessarily be a preliminary issue. In all likelihood, it's a threshold issue, but there are some which are also not, because 16 is a very wide provision. And then saying that, okay, if the arbitral tribunal decides that there are reasons, then it may record those in writing and decide at the end of the award. I think it comes to nothing. Secondly, as Tahira said, one of the very good changes that have come about is this whole issue, and I think Tarun, we've spoken about this before, where if in a 34, you can either, currently the law is that you can set aside the award in toto completely, or you can remand it back to the tribunal. Now, there was a increasing move to say that it should be set aside at least in part. And the Delhi High Court said that, we can apply the principle of severe liability to the award. So if there is one part of the award which can be severed from the other part, which the court has difficulty with, then it can set aside not everything, but only that. And this amendment gives, makes provisions for such a situation, which in my view is actually not really required, because I think the Delhi High Court and the Bombay High Court have already spoken and said that it is possible to set aside an award partially and not entirely. Now, the amendment, there's another issue that has cropped up, and it is this. It says that it should go back to the tribunal. Now, please tell me, if you are sitting as an arbitrator and the court says that, okay, we have difficulty with this one part of the award, and the tribunal is asked to take a second look at it. Right? Now, the point is that the arbitrators will obviously then take a second look at it and give a different verdict. So I think this is another area where you're going to have a little controversy. I think this comes from the thought that after the tribunal has pronounced its award, it is functus officio, which is that they cease to exist, except in certain cases. One was remand, and the other was rectification. But now we have a third provision there, which revives the old tribunal, and the old tribunal relooks at their own decision, which is slightly worrisome. So, and that's going to give rise to more controversy. And there are some other fairly inconsequential changes. So, for example, the courts have already spoken on emergency arbitrators. So, Section 20. The word place comes from the original UN Citral model law. And there was initial difficulty about whether it means seat or venue. And now the law is very well settled that, what is seat and what is venue has been defined. It took a while to come to that level, but it's very well done. And they've just built in to the law what is already actually law pronounced by the courts. So I really don't know what to say. And on the last point, I just have to mention that, I agree with Vyapak that, we have to have two buckets and deal with two differently. But I may not classify those buckets as necessarily as Indian and foreign. Foreign, of course, what Mr. Jain is talking about is enforcement of a foreign award against an Indian party, which is different. If there is a award by a foreign institution, for example, right, that division can well be made. But again, as Mr. Jain pointed out, that, most arbitrations which involve infrastructure disputes, which are very big ticket arbitrations, and where you will inevitably have a PSU. And I remember recently I was speaking to the current ASG in the Delhi High Court also, and he set out very beautifully the what I think Sanjay Jain echoed here, which is that how is it that in arbitration, the PSUs always have the rough end of the stick? And I think he had gathered some numbers and said that, well, look, when you have a big ticket arbitration involving a PSU, it's always the PSU which inevitably loses. Well, if not always, but for a vast majority of the time. And I think the skepticism in the corridors of power about this inevitability, so to speak, is only natural. And I think that's the reason why, again, as Mr. Jain said, that we have the ground of patent illegality to challenge also domestic awards.
Thank you for that input, but I think there should be a distinction between correcting a fault and steamrolling it. The circular simply steamrolls through it, and there is no possibility of any arbitration emerging. I myself have spoken to many infrastructure companies who deal extensively with the government. They all want arbitration to come back, and it's not that the private sector is all for it. There are other voices within the government who also want arbitration. Judiciary also wants arbitration.
There is only one way to fix arbitration in India. Just ensure that a vast majority of arbitration, except maybe the very small ticket arbitration, is institutional. That's the only recipe.
But institution, again, your schedule of fees becomes an issue. Is that an issue?
No, it's been amended. There is the amendment that proposes to remove the schedule fee.
Schedule? Okay.
But it is to be decided by the council. So you have a bunch of bureaucrats deciding.
No, but how will bureaucrats decide how much fees arbitrator can charge? That's what you're saying.
No, we don't know. I think, to be fair, they have brought in, criteria in terms of complexity, etc. of the matter. So there's no one size fits all solution. But the point is, this very notion of having a council to, previously in 2019, it was to grade arbitral institution. Where are we going? I mean, how are bureaucrats well placed to sit and decide this or to recognize? So today, an arbitral institution now has to go to the council made up of secretaries and joint secretaries, etc., and say, please recognize me. Oh, I think it's absurd.
Point well taken. I think this requires a separate discussion, the issue of Schedule 4 institutional arbitration, because this is somehow linked.
But there are many good ways to encourage institutional arbitration.
Point taken, but we'll like to take this up. I'll go to Tahira Karanjawala, partner Karanjawala and Company, for her intervention.
Thank you, sir. So as far as the circular of 3rd June was concerned, I mean, I think this was, I don't think this was a very welcome step. I understand where the skepticism comes from, and, the numbers are there as far as, arbitrations going against PSUs. There is, the skepticism as to whether arbitrations are taking place fairly, whether arbitrators are really following, a fair procedure. So there is this concern, and then you have two other factors, right? One is today there is no automatic stay. So immediately on the award being passed, and the period of 34 expiring, it becomes enforceable. And most courts are now asking for 100% deposit. So immediately, I mean, it can be a very large amount, it can be a perverse award, but even to challenge the award, these days you need to start making 100% deposit, including for governing parties. So that's one. And also, there's also a situation where it's, there's no modification possible at the present time. The judgment of the Supreme Court in Hakim has made it clear that there's no modification possible. So and the challenge is very limited. The challenges are, spelled out in 34, and they're extremely limited. So a combination of these three factors makes it understandable for the government to be skeptical about it. But I personally don't think that the right way is to rule out arbitration. I think it's perhaps something that has to be adapted and modified to our ground realities. And personally, I know this is, a little bit of a controversial opinion, but I personally think that there should be some power of modification in a 34. only so that at least parties are not relegated back to a fresh round of arbitration. And I think this was, I mean, I know this issue is pending presently in the Supreme Court in any case, in Gayatri Balaswamy's case. But I think that the draft amendment bill was a good opportunity for the legislature to clarify if at all modification is possible. So, I mean, that's one thing that I feel perhaps, a power of modification could be introduced. The second thing that I think, the legislature has missed in clarifying is there's been an entire, controversy related to impediment of third parties in arbitrations, whether the arbitral tribunal can do it, whether only the court can do it. The Cox and Kings judgment came out, which, suggested that they can be impeded now. So I think here was another avenue where clarity could have perhaps been provided in the act itself as to if an arbitral tribunal can impede a third party, at what stage, if so, what recourse is available to this third party against such a decision. So these two things, I think, were good opportunities for clarity to be brought into the act. But in general, I mean, I still agree that overall, I don't think it's a welcome move for the government to sort of keep arbitrations below sort of 10 crore threshold, which is nothing as the government
In the dispute resolution framework.
sort of doing away with the entire process. And you can't, on the one hand, want India to become an arbitration hub, and on the other hand, the government, which is the largest litigator, to say that no, we will not participate in this procedure at all, and then have a situation where all companies are then forced to file suits. So I don't think that's the correct approach. I mean, a better approach would be perhaps to amend the act, maybe make it a little more sort of interventionist as far as domestic is concerned, as Mr. Desai, pointed out that I mean, so far we've always been trying to do a mishmash between international commercial arbitration and domestic arbitration, and perhaps an easier way is to just make it, if not into two acts, then into two separate chapters of the act.
Point well taken. I don't know, but if severance will work in the right way, because that would mean going into every award and chopping parts of it. So it would. I don't know how this works. I think I'll go to Vyapak Desai for his intervention.
Sure. So let me first deal with the circular. See, I think one can very well say that the reason for the circular is the awards are going against PSUs. But has anybody looked at how many decrees have gone against PSUs, right? And maybe because suits never get decreed, there are no decrees against PSUs. Is that what you are trying to achieve by taking away arbitrations, right? So I think just because judgments or the awards are going against one party or the another cannot be the reason for taking away the process of arbitration or process of dispute resolution. And if we need to make it better, then we have to work in the direction to make it better, rather than completely take the baby out of the bathwater, as we keep using this phrase as lawyers more often than not. So I think I don't think that's going to be the solution. What if tomorrow there are 20 suits and 18 judgments against PSUs? Where will you go? If at all those are done within 3, 4, 5 years. If it takes 30 years, nobody knows what happens to those suits. So that's point number one. I don't think running away from a resolution system which has worked well for most of the world is an option. What needs to be done is how it can work for us, and therefore at some point we need to also change the nomenclature to say arbitration is not an alternate dispute resolution, it's an parallel dispute resolution. So it's not like you are going away from court as an alternative, it is just a parallel system. You are given some better system which is little more in control, which is possibly little swifter and flexible and faster to deal with business issues. At the end of the day, why do you need a parallel or an alternate dispute resolution system? Courts are there, but there are issues for construction arbitration. There are issues with other specialized disputes, which needs the flexibility of a parallel dispute resolution system or alternate dispute resolution system. So I think that's part one of my thoughts on at least the circular.
Thanks.
On the issue, sorry, I'll just finish
No,
on
no,
the,
no, please
yeah.
go.
See, on the issue of this whole aspect of arbitration council, let me take you a little back where this emanated from. This emanated from a law commission report in 2014-15 by Justice AP Shah. And the words used in the report was Arbitration Promotion Council of India. You know what they have done? They have dropped the word promotion. Uh, so what have they done? They are saying now it is Arbitration Council of India. You are not promoting arbitration. You are regulating arbitration possibly. So you are actually creating a monster out of a body where you are now creating one more regulator to deal with, because now they are making rules. They are deciding which institutions will function. They are deciding how emergency arbitrators would function after they are appointed even by the institutions, right? They will decide the fees. So, and as Percy pointed out, who will decide? It is back to the bureaucrats who doesn't want arbitrations in the first place for PSUs. They will decide how the arbitrations would be run. So I think, I don't know what was the reason for dropping the word promotion, as I said, but I think we need to bring back the intent why the council was suggested. Council was suggested to promote arbitration and not regulate. I think that's and everything will, in my view, the moment we understand the objective and purpose of the body, who should be appointed will be clear. Obviously, there has to be judicial or private practitioners doing arbitrations and not only bureaucrats.
Which
What
was the
they should
original
do,
intent.
that's what I say. So I think we are completely missing out who proposed this versus who is implementing it.
As long
So
as
that's-
these are not linked to government salaries, lot
So
of people
I'll come to the cost and salaries of it, right? I think there is another monster or another animal proposed, which is the appellate tribunal. Now, the discussions and the comments given to the earlier committee, which was proposed, possibly which is the basis of this bill, the issue was, how do we take away court's burden from 34 challenges so that it goes faster? What they have done is they are saying this is alternative to 34. It's an appellate tribunal set up by institutions. Can someone tell me who will man it? Right? Is it another set of arbitrators appointed by institutions? If yes, who will pay them? Because you have already paid one set of arbitrators to give your award. Who will pay to rehear your appeal? Is it again appointed by government? Then who will decide who will sit in the appellate tribunal appointed by an institution? I think this is a completely, either it is not thought through or it is completely misread. The aspect which was possibly suggested was that we need maybe something akin to tribunals, where there is one layer of appeals taken away in 37. So basically from an award you go to 34, and from 34 you go to Supreme Court. So you use the process for reaching finality much faster, rather than sitting in courts and sitting in the queue. Instead, they have now completely misread the aspects of an appellate tribunal without even understanding who will, man it, or who will, take decisions on who will appoint those arbitrators and so on and so forth. Third point, interim reliefs. Again, why I suggested to split the law. At one end, we fought for 20 years to say interim reliefs will be also applicable to foreign arbitrations till Balco came in. After Balco, we said foreign arbitrations, no interim relief. 2015 said interim reliefs for foreign arbitrations. Now we are saying no interim relief the moment there is commencement of arbitration. Point is, there are matters which surely arbitrators can't deal with: third party claims, issues related to certain enforcements. You need section 9 even during the process of arbitration. What about foreign arbitrations where you need interim relief during the process of arbitrations, Section 9 is applicable. Who will deal with it, right? Who, if you are taking away Section 9 during the process of arbitration immediately after commencement, tribunal is not even set up, because a commencement doesn't mean tribunal is set up. Then what happens within that period? You go to maybe emergency arbitrator, and I'll come to problems with that as well. But what I'm trying to suggest is, we are, completely like we are doing, patching work without understanding how it is affecting the other provisions or other regimes. And that is one reason why we really need to, simplify this into completely two different buckets. And I know, Tarun, you said there are issues in that context as well, and I am not, completely ignoring them. But I think the confusions that we are creating by not splitting it are even more worse. So I think we are just looking at pros and cons of it. And coming to emergency arbitrator, right? Very well. Now, 2015, even emergency arbitrator was proposed. Legislature said no. Maybe after 10 years, you are saying, yes, good, you have changed. But then what you are saying, council will determine the rules for emergency arbitrator. How will that ever work? What if an institution appoints them? I think they have just not thought through the aspects. And same thing in terms of the enforcement of interim orders. They simply include this as part of 9A2, not understanding that what if the emergency arbitrator is appointed in a foreign seated arbitration? How would that apply to Section 17? And there are judgments and law to say that emergency arbitration awards will not be appealable in the 37 because they can still be modified, right? But then now they are akin to 17. So what I'm trying to suggest is, you don't have to insert sections and try and deal with those issues like a patchwork, right? Otherwise, only thing we are going to do is litigate arbitrations rather than arbitrate merits of the disputes, right? If we want to litigate the arbitration law, I think there is no problem. This is a perfect recipe for this. But if you really want to arbitrate the disputes on merits, then definitely this requires much more thinking than what it says. But again, I don't want to take too much time because there are obviously.
No, but today was good. I liked it. Today was a good, fair, in-depth discussion on this issue. Of course, we would like to discuss the circular and some doubts that may be existing some more on the next show, because that is a persistent demand that this indication from the government has ensured that no new arbitrations are happening, which is not good as far as India's aim to become the hub of arbitration is concerned. I think some work on that is still left. Mr. Jain gave a hint of news that, it may be soon that things may change, but of course he's not told us the whole story. Maybe he knows something which he's holding to his. But that's for another show. I would like to thank Senior Advocate Sanjay Jain, Senior Advocate Percival Billimoria, Tahira Karanjawala, partner with Karanjawala and Company, Vyapak Desai, partner with Nishit Desai Associates. Indeed, a very interesting show on an interesting topic. Hope we see some changes to the bill, and also hope very soon that the circular of last year is withdrawn by the Ministry of Finance. Thank you for joining in. Thank you so very much.